Most people think disputes are decided by arguments. They imagine a courtroom where facts are presented, logic prevails, and the strongest case wins. But high-conflict disputes rarely operate that way. Long before any final judgment is delivered, something else is already happening. Pressure, legal pressure, not always unlawful, often perfectly procedural, but strategically applied in ways that change behaviour. Today, we are going to examine how pressure functions inside disputes and why understanding it changes how you respond. Legal systems are built on procedure, applications, responses, deadlines, disclosure obligations, court appearances. Individually, each step is reasonable, but together they create a structure that can be extremely demanding. Every procedural step requires time, preparation, money, attention, and when these demands accumulate quickly, they produce something powerful: cognitive compression. The individual under pressure must make decisions faster, with less clarity, under greater emotional strain. That environment is where strategic mistakes occur. Not because someone is unintelligent, but because sustained pressure alters how people think. One of the most common pressure mechanisms in disputes is procedural volume. Multiple applications, frequent filings, requests for extensive documentation, urgent deadlines. Each step may appear legitimate on its own, but collectively, the volume changes the environment. The responding party must constantly react. Legal fees accumulate. Time becomes scarce. Attention fragments. Eventually, the individual stops thinking strategically and begins thinking defensively. That shift is where leverage changes. Another powerful dimension of legal pressure is financial asymmetry. Litigation is expensive. Lawyers must be paid. Experts must be retained. Documents must be reviewed. If one party has significantly greater financial endurance, the structure of the dispute changes. The better funded party can afford delay. They can afford appeals. They can afford to sustain multiple procedural engagements. The weaker party must constantly calculate the cost of continuing. This does not mean the wealthier party automatically wins, but it means the strategic environment becomes uneven. And uneven environments change behavior. The third dimension of pressure is psychological. Disputes create uncertainty. Reputation may be at risk. Financial stability may be threatened. The future becomes unpredictable. Under these conditions, even disciplined individuals begin to react emotionally. Emails become sharper. Communication becomes reactive. Decisions are made quickly rather than deliberately. And these reactions often create additional vulnerabilities. Pressure rarely needs to break someone completely. It only needs to create enough instability for mistakes to occur. Understanding pressure changes how you respond to it. The instinctive response to pressure is escalation, but escalation is rarely the optimal strategy. Strategic discipline requires something different. First, conserve cognitive bandwidth. Not every allegation requires engagement. Second, slow the decision cycle. Important decisions should never be made while emotionally destabilized. Third, analyze leverage rather than activity. Procedural volume can create the illusion of momentum, but momentum and advantage are not the same thing. Pressure is often highest in the early stages. Once the environment stabilizes, clarity can return. Pressure is one of the least discussed dynamics in disputes, yet it is one of the most influential. Understanding it does not eliminate pressure, but it allows you to recognize what is happening, and recognition restores strategic distance. Because the moment you understand the structure of pressure, you begin to recover control over how you respond. If you are navigating a high-conflict legal or commercial dispute and require structured strategic perspective, including leverage mapping and risk framing, you can request a private strategic assessment through the link below. This is not legal representation. It is structured analysis designed to help you think clearly under pressure. I review a limited number of matters each month. Details are in the description. Most disputes are not lost in court. They are lost in preparation. This is the strategic brief.